good morning, good evening, good afternoon. Hello, my name is Chava Kari, and I have the honor of welcoming you to today's event. We have the opportunity to hear from innovative, extraordinary women, trailblazers in their field. We are starting the day in Haifa at the Mashab Mount Carmel International Training Center, moving on to Jerusalem, Rome, and San Francisco, and Tel Aviv. Welcome and thank you to our amazing panelists and to the hundreds of viewers on Zoom and on Facebook Live, experts in the field of combating human trafficking, as well as honorable ambassadors and members of the diplomatic corps from all around the world. Thank you to the staff here in Haifa and to my colleagues Rana Suidan and Yuda Michael for being with me today. And now I'd like to ask Rana to say a few words about the logistics of today's event. Rana, please.
All right, thank you very much, Chava. Good afternoon, everyone. It's a pleasure to welcome you here today. I will start with letting you know that this session is being recorded and is shown on Facebook Live. You are welcome, of course, to share the link from our Facebook page with whoever you please. This session is being translated simultaneously to Russian, and for the Russian translation, please press on the button Interpretation in the bottom of the screen with an icon of the globe, and then choose Russian. Please see the written instructions in the chat box that I will upload in a minute. We will, of course, ask the audience to be on mute during the session in order to give the speakers the stage to speak. Please feel free to put your questions in the chat box, and we will read them out to the experts at the end of the presentation. We'll try to get to as many of your questions as possible. Thank you all very much and enjoy the session. Back to you, Chava.
Can unmute. Thank you very much, Rana. It now gives me great pleasure to introduce Ambassador Einat Schlein. Ambassador Schlein is the head of Mashab, Israel's International Development Agency, and Deputy Director General at the Ministry of Foreign Affairs. Ambassador Schlein is Israel's former ambassador to Jordan and a renowned authority on the Middle East region, Israel-Arab relations, and American affairs, promoting dialogue and understanding in the region. Ambassador Schlein also has held senior positions in Washington, D.C. and Boston, as well as at the Israeli Ministry of Foreign Affairs in Jerusalem. Ambassador Schlein, I'm delighted to pass the microphone to you to open the event today.
Thank you, Chava. It's a pleasure to be here. I shall say good morning, San Francisco, good evening, Asia, and good afternoon here from very stormy Jerusalem. It's a pleasure to be here today, and I'm very glad to see so many friends joining us around the world. Obviously, the topic that we're speaking about is an unfortunate phenomena which touches the lives of many people, and Israel, just like all of the people around this virtual table and other governments, is doing its utmost to try and fight this phenomena, minimize it, and hopefully eliminate it. So how is Mashab related to this topic? Let's speak for a few minutes about Mashab. Mashab's Israel Agency for International Development Cooperation at Israel's Ministry of Foreign Affairs. It's responsible for the design, coordination, and implementation of the State of Israel development cooperation programs and humanitarian assistance efforts. By placing people at the heart of development, Mashab focuses its development activities on human capacity building based on training the trainers approach, sharing with other countries Israel's own development experience and expertise, as well as innovative technologies and tested methodologies. This is relevant to many fields, speaking of food security, public health, innovation, and also fighting human trafficking. In alignment with the 2030 Sustainable Development Agenda, and as a member of the family of the nations, the State of Israel through Mashab shares the global responsibility of striving to overcome development challenges and contributing to the fight against poverty while leaving no one behind. Achieving sustainable development is viable only if all areas of society participate. Government, international organizations, academia, the civil society, the private sector, and the public in general must work in partnership to ensure that ideas are translated into concrete progress. Mashav is very committed to these goals. It always has been, and under the pandemic and its unique challenges, we stand ready to offer our assistance, share knowledge, and most of all, hold hands together and integrate our efforts in this very important fight. Thank you very much.
Thank you very much, Ambassador Schlein, for your thought-provoking and remarks. We appreciate very much your coming on with your busy schedule and taking time to be with us this morning. And now I have the honor to introduce our moderator for today's panel, Advocate Rachel Gershoni, a lawyer for the past 40 years, specializing in the field of criminal justice and evidence.
This panel moves us beyond an emphasis on law enforcement to an emphasis on victim protection and broad-based prevention of trafficking. In doing so, the panelists both follow the Trafficking in Persons protocol and move beyond it. How do they follow it? Well, in one sense, the Trafficking in Persons protocol is a criminal convention. It's not a human rights convention. However, it did something very groundbreaking in devoting an entire section to victim protection and in addressing prevention, including fighting root causes like poverty. Now, so in these ways, the panelists who will focus on victim protection and prevention follow the protocol. However, I would say that they also chart a new course. And I think that at this crossroads, 20 years after the protocol was adopted, we have garnered insights about what victims really need and what kind of preventions we need to undertake in order to stamp out trafficking. So at this crossroads, these panelists will address insights which have been gathered in the 20 years since the adoption of the protocol. Each in her own way is a pioneer and innovator. Dr. Maria Grazia Giammarinaro will focus on the need to change our emphasis on law enforcement to an emphasis on the human rights of victims and the obligations of states to foster social justice in the quest to end trafficking. Judge Susan Briel from San Francisco will focus on how to design a victim-friendly court and will unfold a new model of individual care for juvenile victims of trafficking. Advocate Dina Dominitz, the new trafficking coordinator in Israel, will talk about the need to design different kinds of protection for different kinds of victims, and also how to assist victims make their way through the criminal process. Advocate Alexandra Kara will talk about how vulnerable victims are ensnared by means of the internet and how we can act to prevent this, not only by means of criminal enforcement, but also by means of a new law which authorizes a court to block access to certain sites. So I think that at least one of the messages that we can carry forth from this panel will be not to forget the victims in our quest to punish the traffickers and to listen to their voices. Our first panelist, whom I will now introduce, is Dr. Maria Grazia Giammarinaro. She is a Renaissance woman, a broad-based education, interests, and skill. She has functioned as a judge. She's been a leader who has contributed to groundbreaking initiatives in the field of trafficking and other areas, both in her native Italy and internationally. I'll give only a sample of her many achievements. She served as the United Nations Special Rapporteur on Trafficking in Persons in the Office of the High Commissioner for Human Rights. Some of the recommendations which she will share with us today were forged in this capacity. She also served as the Special Representative of Combating Trafficking in Human Beings of the OSCE. In addition, she served in the European Commission's Directorate General for Justice, Freedom and Security, and there she drafted the European Union Directive on Preventing and Combating Trafficking in Human Beings, which I'm sure many of you know. She was also a judge in the Criminal Court of Rome, and in her capacity in Italy, drafted the progressive Italian legislation. With such wide-ranging achievements, it's no wonder that she also has varied areas of education, with a degree in Italian literature as well as in law. And she also was a school teacher for a few years. So here we have, as I said, a Renaissance woman. Maria Grazia, let's hear from you.
Thank you, Rachel. It's really a pleasure and a privilege to be here today. I had in the past the pleasure to take part in one of the trainings for judges, so I know the work of Mashav. And of course, as you said, some of the reflections I will present today have been forged during my tenure as UN Special Rapporteur on Trafficking in Persons, especially women and children. And especially in my last report to the Human Rights Council in June last year, I tried to summarize somehow my assessment on the current state of play regarding trafficking and anti-trafficking action, and try to figure out how we can take a step forward. Of course, 20 years after the Palermo Protocol, we are obliged to take stock of what has been achieved and what we still, the issues we still have to face today. And we have to think that the Palermo Protocol, not only, as Rachel said, is a criminal law instrument and not a human rights instrument, but we have to think also about the fact that it was adopted very early, in an early stage of what we can consider the current features of trafficking in persons. So it is clear that the Palermo Protocol is a flow instrument from the point of view of victims' rights, and the negotiators were intelligent enough to understand that the protection of victims were becoming more and more an important issue. And in the very late stage of the negotiation, the protection of victims was introduced in the protocol as a prominent part of the protocol. However, weaknesses were there from the very beginning. We noticed that the fact, for example, that the provisions concerning victims' rights are mostly non-binding, that the unknown punishment provision is not included in the protocol. And I'm very, very happy to say that today, the European Court of Human Rights issued a judgment, a very important judgment, in a case of cannabis cultivation, in which children, juveniles were found in a situation, of course, that now the court recognized as a situation of forced labor. And so the court recognized that in this case there is a violation of Article 4 of the Convention, which is enormous step forward toward the recognition of victims' rights in cases in which, against their will, people are forced to commit crimes, and even serious crimes, because of course drug cultivation is a serious crime. So not only in petty crimes such as the use of false documents, for example, but in a case of a serious crime. I would like to say that the protocol still shapes the way states and governments deal with cases of trafficking, in the sense that very often worldwide, the identification of victims depends on police operations, and the decision-making is entirely in the hands of law enforcement and or immigration authorities. The result is the fact that trafficked and exploited people, if they are not correctly identified in the context of a criminal law qualification of the crime, are deprived of the possibility to access assistance, residence status, and importantly, in many countries, also remedies because of their irregular status, for example. So the protocol is somehow an old instrument that should be complemented by, and this is my reflection today, it should be complemented by a human rights-based instrument. Because, of course, for different reasons, but the main reason is that the protocol dealt with a criminal phenomenon. Criminal phenomena, unfortunately, are marginal in societies. But now we face a situation of labor exploitation, also sexual exploitation, but particularly labor exploitation, which is installed in a very relevant way in many sectors of our economies and labor markets. Agriculture, tourism, touristic industry, manufacture, textile, transports, domestic work, construction. We see that we are dealing with a systemic issue. And of course, the Palermo Protocol is not an instrument shaped to deal with systemic problems of the labor market, such as trafficking trafficking, and in general labor exploitation is today. Of course, the protocol and its provisions should be interpreted in the light of subsequent developments, including the ILO protocol on forced labor, including the jurisprudence of the Inter-American Court and the European Court of Human Rights, which has, for example, expanded enormously the prevention obligations of state and the obligations related to the protection of victims. It should be complemented by initiatives adopted voluntarily by businesses, trade unions, and workers-led initiatives. But at the end of the day, I think that new legislation at the national level and a new human rights instrument at the international level is needed to put in place a legislation ready to deal with this enormous problems of exploitation, which are exacerbated by the COVID-19 situation. Of course, exacerbating vulnerabilities of people losing their employment, becoming even more vulnerable to exploitation, and especially women who are losing their jobs more than men. And the risk is that the feminization of poverty, which is already there, already in place, will become even more serious. So just a few points regarding the content of what we need in terms of new legislation. First of all, prevention. And I just mention, of course, prevention is an area, an enormous area dealing with root causes. And of course, international cooperation is paramount in this field. But also corruption, racism and xenophobia, the fight against discrimination on any grounds. But just to mention one element that should be, that has been already highlighted by ILO, for example, the Alliance 8.7, recruitment. Recruitment is very often the criminal segment. The intermediation is done with high fees charged on workers, which create a debt. And this debt, of course, is the source of very serious exploitation. My second point is about remedies. Victims, regardless of whether the situation is qualified as trafficking, forced labor, or even labor violation of labor laws, so minor violation, should have access, easy and free access to remedies, including the payment of salaries, including compensation for damages. But we have also to think about reparations for gross human rights violations, such as, for example, the restoration of work, of employment, and the real need of many people exploited at work, but also of people exploited in the sex work, is about another opportunity, another job, a job in a non-exploitative situation. And this is exactly what they don't get. They don't get an alternative for life, and they don't get money in compensation of the exploitation borne. My third point is about early support of people, not only people that have been formally identified as victims of trafficking, which are an absolute minority, but also of people that can be recognized vulnerable to exploitation and trafficking, through special procedures to be put in place, for example, in transit countries and in places of first arrival of migrants, where confidential procedures should be established for the purpose of early support. And my last point is about social inclusion as the final goal of support and assistance, which means that not only short-term measures should be in place, but also long-term sustainable measures aimed at identifying a viable solution. Thank you very much for your attention.
Thank you very, very much for actually mapping out for us where we stand today, what has been accomplished, and what remains to be done. And wow, okay. So now we move on to Judge Susan Briel. And when I was reading her biography, I said to myself, you know, we always ask in this course that I teach on social change, we ask, can judges effect social change? And reading her biography, I think we can answer a resounding yes. Because not only is Justice Brill, she's been a judge for 19 years and is currently a judge in the Superior Court for the city and county of San Francisco, but in her capacity in a juvenile delinquent court, she created the first girls' court in San Francisco, addressing cases involving girls at risk for sexual exploitation and trafficking. She has some history with fighting trafficking. She was appointed to the California Alliance to Combat Trafficking and Slavery Task Force by a Supreme Court Justice in the United States, Sandra Day O'Connor, and she spoke at the International Summit, which was organized by this justice at Arizona State University. She does numerous judicial trainings, both nationally and internationally, on trafficking and allied subjects. And her judicial work has included presiding over domestic violence courts, drug courts, felony settlement courts, and serious adult criminal jury trials. I have found, actually, in my experience, that the more areas one deals with which are outside trafficking and yet related, enrich your thinking. And I think that this is part of what has happened to Justice Brill, and we would like to hear from you now.
Thank you so much. It is extremely inspiring to be here with so many experts from around the world. For some of you, it's early or late in the evening. For me, it's very early in the morning. But no matter what time of day it is for you, no matter where you are physically in the world, the concern and the interest you've shown by being present here today helps reaffirm the worth and the dignity of all survivors of human trafficking. We have a saying at the National Council of Juvenile and Family Court Judges that there is no such thing as a child prostitute. And what we mean by that is that it is not correct to label or classify such a child as anything other than perhaps a survivor of commercial sexual exploitation. Certainly in the United States, we have as many forced labor trafficking cases as we do forced sex cases. In fact, according to the National Institute of Justice, we have more forced labor cases than forced sex cases. But I'm going to use my brief remarks today to talk about domestic child sex trafficking and a new court model to assist such child victims and help them get back into care. For too long, courtrooms around the United States have had a great deal of difficulty engaging youth between the ages of 12 and 18 who have been commercially sexually exploited. Too many young people have not been helped by our court systems. Children go missing, and in many jurisdictions, the search for them is only perfunctory. Or if they're found, the courts have not been able to successfully re-engage these children or bring these children back into care. These children are not in school. They have high rates of teen pregnancy. They lack sexual health services, and their issues of trauma have not been addressed. And when I say trauma, it's not just the trauma that they have suffered at the hands of their traffickers, it's the trauma they've been exposed to in their homes of origin, which often have caused them to leave their homes and then be vulnerable to human trafficking. A courtroom model I implemented to re-engage these young survivors is a harm reduction model, a team approach in handling these cases. The team is comprised of advocates from NGOs who really have expertise with commercially sexually exploited children and who have trained me and educated me. Second, child protective service workers, social workers from the government. A third team member is an attorney appointed by the court for the youth. Fourth, a government attorney. And finally, a CASA, or a court-appointed special advocate for the youth. The goal is to help the youth re-engage in services they are absolutely entitled to, such as safe housing, education, and therapy. This model involves intensive discussions and collaboration with the team members, and then intensive discussion with the youth. And we will sort out all the issues, the problems, the needs of each youth. And all those problems, needs are often unique. If these children suddenly fail to show up during this process in court, members of the team will find the child, but they will not be detained or forced back to the courtroom. They know we are concerned about them. They know we want them to be safe. We work with each youth to come up with individual achievable goals. And many of their goals have a common theme. Don't run from placement is one. Graduate from high school and get into college is another goal. Learn how to cook is one young woman's goal, and we're helping her get a stipend to the Culinary Academy. Write tap music is another goal of a young person. When their goal is achieved or even partially achieved, they are rewarded. And the rewards, like the goals, are survivor-centered and come from the youth themselves. Gift cards are often chosen. One young woman wanted false eyelashes, and another simply a pair of warm slippers and a pair of warm socks. We do not force these children to do things. We do not issue mandates. I do not issue what seems like inflexible orders, because I've found that this doesn't work for this particular population. And again, I'm talking about youth between the ages of 12 and 18. All of the youth in my court are young women, which is not to say that I don't welcome young men who are vulnerable to trafficking or who have been trafficked. Most of all, these young people want a home. They don't want a trafficking shelter to go to. They don't want an out-of-home placement with 10, 15, or 20 other young people. They want a home. And as one young woman said to me recently, who was 12 years old, Judge Briel, I just want to be a regular girl, and I just want a regular home. So we in San Francisco are at the beginning of a new pilot project. It's called the FAM Pilot Project. It is an experimental program for housing and engagement for sexually exploited youth in San Francisco. It stands for Family and Me, and it is a family, truly a family-based foster care pilot program for commercially and sexually exploited youth. It's based on something called the Florida Project, and it works to identify a family option sometimes from the extended circle of people the youth has had a relationship with, and sometimes a family unknown to the youth. And these individuals are specially trained caregivers. They open up their homes for the youth. They're supported by a government grant, and it's much more than normal foster care. They are trained on issues of human trafficking, and there is a primary caregiver and a secondary caregiver. The secondary caregiver will provide mentorship with the youth, and the youth can live with the secondary caregiver for short periods of time as a respite for the main caregiver. And we find that a respite will be needed because these youth have high-end mental health and emotional needs. Both caregivers are provided ongoing education and training, not just in the realm of commercial sexual exploitation, but they're given training on educational needs. They're given training on healthcare and other issues, for example, positive relationship building for the youth. And the caregivers are helped to introduce the youth or reintroduce the young person to relationships with their biological family, if possible, whether locally, nationally, or internationally, as long as the family members themselves were not the traffickers or the perpetrators of the abuse. We as judges do not have all the answers. We need training, we need education and public awareness, not just notices in bathroom stalls at international airports. We need to understand and to address the root causes of all violence and abuse. And this is a long and arduous journey. This is a journey that I believe we can only be successful in if we take this journey with each other together. Thank you so much.
Thank you so much. This is a tremendously innovative, individualized program which recognizes what every practitioner in the field of trafficking knows, that very often these children have gone through multiple traumas, and it's not just the trafficking. And what sticks with me most from what you said was what that girl said, that young girl, I just want to be a regular girl with a regular home. And that's listening to the victim. That's what she wants. She wants to have a regular life. Anyway, your presentation also connects with the next presentation by Advocate Dina Dominitz, who also advocates individualized programs for victims. So Dina, where are you?
I am here. I hope that you can hear me.
Okay, Dina. So Advocate Dina Dominitz, I've known for many years. And I must say that one of her dominant characteristics is initiative. Present her with a problem, she will find a solution. Not only will she find a solution, but she'll do it by building collaborations. She is Israel's anti-trafficking coordinator, and I always say the ultimate trafficking coordinator. She promotes legislation, identifies new trends, does research, is a source of expertise, but never forgets, with all her many tasks, never forgets the individual victim. And I remember at one point, I wasn't going to mention this, but there was a woman who was imprisoned for domestic violence. And Dina fought to have this woman recognized as a victim of trafficking. She fought against every government authority, and she succeeded. And this is the kind of woman we're talking about. She, of course, has an experience also in the state attorney's office and formerly in the Ministry of Interior. And in both these capacities, she was ever innovative and continued to work in anti-trafficking work, even when she was a member of the Ministry of Interior, which, as every practitioner in trafficking knows, is a problematic office. Okay, because the office is concerned with illegal immigration, and many trafficking victims are illegal migrants. So, Dina, so let's hear from you.
Thank you, Rachel. Wow, for that introduction. I'm sorry I'm so technologically challenged today. I'm on my phone, but I hope that everybody will be able to hear me and more or less. So as Rachel said, I really am continuing Judge Briel's words about protecting victims of trafficking, and I'd like to share some of our insights and thoughts after 20 years or nearly 20 years of protecting and rehabilitating victims in Israel. Israel was one of the first countries worldwide to set up, to establish a state-funded supervised shelter for victims of trafficking, and this was in 2003. Since then, every victim who is recognized as a victim of trafficking, and this is done in Israel currently by the police, who have the authority to recognize victims and refer them to the shelter. Every victim who is referred to the shelter is entitled for 1 year of rehabilitation, which includes a working visa issued by the Ministry of Interior. The shelter, of course, assists the victims in finding a suitable place of work, which is protected and normative. This also includes all medical care, psychological care, psychiatric treatment that the victim might need, psychosocial therapy. And in addition, also the victim is entitled to state-funded legal aid by the Ministry of Justice. And accordingly, they can be represented by a state lawyer who can issue civil suits for damages against the traffickers, or represent the victims again, in front of the authorities in matters pertaining to their status, to their legal status in Israel. And it's important to note that all these rights and protections are non-conditional on the victim's willingness to cooperate with the authorities, with the enforcement agencies or not. They are entitled to this year of rehabilitation, which can also be extended in special circumstances. Whether or not they wish to cooperate, or perhaps they are unable to deliver any information, they are still entitled this year. But victims who do choose to cooperate and give testimony in the criminal proceedings are also entitled to stay in the shelters, including all the rights that I have described, throughout the duration of the criminal proceedings. And when those are finished, then they are entitled to another year of rehabilitation, because our perception was that while they are testifying and being investigated during the criminal proceedings, they are not really able to focus on rehabilitation, and therefore we assist them in giving one additional year in the shelters, as mentioned. And really, we have seen over the years that the shelters are the place where humanity is restored to people who have been treated as objects, people who have been treated as means to make profits. And the treatment in the shelters is done with much thought and sensitivity. However, after 20 years or so down the road, we see that many of the patterns have changed. The trafficking patterns, we know that they are very dynamic and they have changed. And also the professional perceptions have also changed. And we just started to examine ourselves, basically, and to rethink the whole model of protection of victims, starting with what their needs are, the different kinds of victims, and what is rehabilitation when we're talking about victims of trafficking. What does that include? We also compared, we went into a comparative examination of other countries' models, and we came to many conclusions that are basically supported by the new national plan that we are working on the past 2 years ago in the government. And I will just share a few of our thoughts on this matter. So first of all, as I said, victims come in all shapes and sizes and colors and ages and gender. And one size does not fit all. So while we've had basically a one-size system up till now, now we realize that we have to develop alternative tracks to meet the different needs of the victims. Up till now, if a victim did not want to live in the shelter, basically it was very difficult to award many of the rights, both a working visa and also medical care. Was very, very limited because everything was based on the stay in the shelter. And when we talk about professional perceptions, we also realize that although staying in an institution, in a shelter, which is 24/7, very supervised and rigid framework may be suitable to some of the victims. It is not necessarily suitable for all victims. And even we realize that in many cases, the victims, in many cases, the victims even have a regression in their status, because the fact that they are made to lose basically most of their independence and their autonomy and placed in an institution which causes them to be totally dependent on the state for all their needs, starting with their food and the diet, and also when they can leave and when they can go and visit their friends. So basically, the main perception today is that this is not suitable to many of the victims. Particularly, we see this with in Israel. We have many victims for sex trafficking that are brought to Israel for purposes of prostitution, and most of these women are independent women. They're used to living in good conditions, to earning money, and they don't see themselves as victims. And it's very hard to persuade them that suddenly, when they are apprehended, they should now enter a shelter. They see this as kind of a punishment. So all these thoughts have led us to develop a new model, which basically will be based much more on the day center. And we intend to turn that into basically a one-stop shop. Because another factor that we have to take into account is also the fact that many of the victims are indeed witnesses and who do cooperate with the enforcement agencies and are participating in the criminal proceedings. So we need to also adapt ourselves in the criminal proceedings to the needs of these victims without, of course, compromising the defendant's rights. Today already, according to Israeli law and regulations, victims we can request testimony behind closed doors. We can also request that the victim does not testify in front of the perpetrator or in closed circuits. And many other rights. Victims are entitled to compensation within the criminal proceedings. But we've also realized that these victims also need somebody to accompany them, somebody to represent their rights and to make sure that their rights are realized. And we are now promoting a new legislation that will allow the legal aid to represent the victims throughout the criminal proceedings, as well as the civil proceedings that I mentioned before, which we believe will be a very important factor. The idea is that this new model will allow the victims to live in society, to integrate basically back into society, be independent, work, receive a working visa, work in whatever job they choose, and every now and again, according to the program that the case manager, the social worker will build for them, they will arrive to receive treatment in the center. They will arrive to meet with the police. The police will have a special investigations room that will take place in this center. The legal aid lawyers will be able to have the meetings there. And basically, the victims won't have to go from different places and turn up at the police station, which can be very intimidating for victims. So we believe this would be a better solution to the model that we have today. Of course, the shelter will always exist, and all victims initially will be transferred to the shelter because we have to have a certain amount of time to assess their needs and also the danger that they are in. Some of the victims are, of course, in high danger from the perpetrators, from the traffickers, and need to be protected. So this is only, of course, able to do in the shelters. But after this initial period of time, the case manager will then provide a program and decide personally for each victim which track will be recommended. And we're going forward with this model at the moment, trying to solve all the different relations that when you change a model after so many years, there are always difficulties because people, you get used to it, and there is inertia of this is how things are done. And once you change something, everything else also has to adapt itself. And I foresee we will have a few difficulties, but as Rachel said, we will overcome those too, and hopefully be in a better place, allowing the victims to be heard better and to their needs better served. Thank you.
Thank you very much, Dina. Clearly, a lot of reflection has gone into this new model, and also a lot of true listening to victims' needs, which is something we all say we do, but very few of us really do. So thank you very much. Now we move on to the youngest of our presenters, of our panelists, Alexandra Kara. And even though she's young, she has very wide and a broad experience. She worked in private practice in the field of government corruption and white-collar crime, in the Ministry of Public Security as a prosecutor, and as a senior attorney at the Tel Aviv District Attorney's Office. She presently serves as senior attorney at the Cybercrime Department of the Ministry of Justice, and she will be able to draw on this experience to explore how we can prevent the use of the internet for ensnaring vulnerable populations. I must also mention that she has received numerous awards for outstanding achievements from the Ministry of Justice, the Tel Aviv District Attorney's Office, and even Israel's Civil Service Commissioner. And like all our panelists, she's a broad person. The breadth of her legal experience is mirrored actually by the fact that she speaks 6 languages. This is a very rare accomplishment in our day and age. So thank you. We'd like to hear from you.
Thank you, Rachel. Thank you all. I would like to start with a small glimpse to the State Attorney's Office before I dive into prevention. And I would like to start and say that each year, the State Attorney's Office in Israel publishes a report regarding its contribution to combating human trafficking in all relevant departments in the office. The pandemic this year may have caused some delays in court sessions, but it did not stop the office from conducting proceedings in court and accompanying investigations regarding human trafficking. Now, I know you have heard this a lot in the past year, but 2020 was a challenging year for us all. A worldwide pandemic led to closed borders, lockdowns, social distancing, and affected many aspects of our lives. We have found ourselves in the face of a new reality that forced us to readapt as we shifted to remote working, moving the majority of our activity online. Banking, studying, keeping in touch with our family and friends, working, and even shopping for groceries. And while the world focused on health and economic threats, cyber criminals around the world were and undoubtedly still are taking advantage of this crisis. We're talking about phishing attacks, fake news regarding vaccines, and naturally a rise in sexual online offenses targeting children and human trafficking in different patterns. When we talk about human trafficking, we talk about human trafficking for the purpose of prostitution, trafficking of organs, trafficking in humans for labor and servitude, and even for surrogacy. And we have learned that given the platform, some forms of human trafficking can be found and executed online with no need of physical trafficking or crossing borders, but with a switch of a camera, a laptop, or other technological tool. On a general note, I would like to say that in the past year, we have seen a decrease in the amount of criminal cases regarding trafficking for the purpose of prostitution, which we naturally believe reflects the success of enforcement efforts and joint activities of all law enforcement agencies, and to the deterrent punishments imposed by the court. Now, by decrease, I am referring to the classic trafficking for the purpose of prostitution, which combines the trafficking across borders, imprisonment, threats, servitude, and so on. Now, my emphasis will be on trafficking for the purposes of prostitution because my department, the cybercrime department, focused mainly on this phenomenon, although we have also dealt with trafficking of organs in the cyber arena, like removing groups in which people interested in organ donation could post their requests, and we did that following a criminal investigation. Now, part of monitoring changes in patterns of trafficking in women for the purpose of prostitution and drawing the required conclusions from it, the state attorney's guidelines concerning the enforcement policy and offenses related to prostitution was amended in order to clarify what actions would be regarded as a sexual contact, following rulings of the Supreme Court, which determined that the act of prostitution consisted of two factual foundations, the sexual contact and the compensation. And the guidelines also specified that in some cases, lap dances, as commonly found in strip clubs, could be considered as sexual contact and therefore a prostitution. And as a result, the state attorney's office is currently accompanying an investigation regarding suspicion to committing offenses for prostitution for the existence of lap dances in 3 different clubs. Now, there is much to be discussed, but in this short time that we have together, I will try and focus on the work conducted in the field of prosecution and prevention at the Cybercrime Department, which is a fairly new player in the arena of combating human trafficking. The Cybercrime Department was actually set up in 2015 and worked in several fields: prosecution, alternative enforcement, and as a consultant to other offices. In the prosecution fields, the department accompanies investigations held by several police units, like the 105 unit in the Israeli police, which is a new police unit set up in 2018, dedicated to protecting minors online as part of the Child Bureau, Protection Bureau. This unit comprises of an investigation unit and a 24/7 hotline, staffed by police officers with special training, as well as representative of other ministries, such as the Ministry of Public Security, the Ministry of Education, Health, Labor, Social Services, and of course, the Ministry of Justice. Now, the unit investigates offenses that target minors, naturally, such as bullying, sexual offenses committed online, sexual harassment, and this past year, it has targeted online prostitution in minors. Now, a general note regarding the substantive law in Israel: the legal approach is to apply the existing laws on crimes committed online. For example, the legal provisions relevant to tackling child sexual abuse material, sexual offenses, prostitution are all applied to offenses committed online. And as we have seen in the past few years, we had conviction and sentences that were ruled by the court in Israel, precedential cases. For instance, we had a case in which the defendant was convicted of multiple offenses of trafficking in persons for the purpose of causing them to participate in an obscene publication or performance, and for committing sex offenses for different sums of money, using the cyber arena against his minor daughter. This was a precedential case in Israel, as the father was convicted of trafficking his own daughter and as a party to the transaction. And he was sentenced to 15 years imprisonment and suspended imprisonment. And he submitted an appeal against the severity of the punishment to the Supreme Court, and he was rejected. And the Supreme Court, in his decision, stated that the appellant used his own young daughter to satisfy his own sexual urges and those of others, both out of greed for money and in a distorted parallelogram of exploitation within which the dignity and privacy of young girls were trafficked as if they were objects. And all this by the hands of those who were supposed to protect them. So this was quite a precedential case. Moreover, and part of the goal to tackle minor prostitution online, which is quite a new phenomenon that we have seen in the past year, indictments were filed against defendants who were clients of minors working as prostitutes, even in unique cases where the Prostitution Act was conducted online and did not involve physical contact. In cases where obscene materials were created at the request of a suspect and sent to him by the minor, our policy is also to indict on charges of production or possession of obscene publication. So as you can see, alongside the decrease in criminal investigation and indictments regarding human trafficking and prostitution in its classic form, the police and the state attorney's office continue their efforts to deal with this phenomenon by broadly interpreting the law in order to protect minors, women, and victims in general. And another mean is enforcing the law also with respect to ancillary offenses, such as holding a place for prostitution, advertising prostitution, and so on. Now, the latter is very much needed in order to, and pardon me for the use of the following word, strip these offenses from their power. The prostitution industry rolls a huge sum of money and creates a comfortable climate for the exploitation of victims. Which brings me to the question, how can we prevent online trafficking? Now, as I mentioned before, the Cybercrime Department engages in an alternative enforcement channel. This channel is not within the criminal procedure. It is quite relevant to our discussion. The Cybercrime Department in the Israeli State Attorney's Office is the designated department in the Ministry of Justice that files requests for warrants under the Powers to Prevent Online Offenses Act enacted in 2017. Now, the requests for warrants are submitted to the district court, asking the court to issue warrants to Israeli internet service providers, ordering them to either block access of their users to websites depicting child pornography, websites used to publish prostitution, drug trafficking, online gambling, and websites of terror organization. And the goal is to block access to prevent the continuation of the activity. It's rather targeting the publication itself and not the publisher. Now, there are a few courses of actions that can be taken depending on the location of the website in question. Court can issue a warrant demanding the Israeli ISP to block the website in whole or in part when discussing content hosted outside of Israel, and removal of websites when the content is hosted in Israel. Now, when we discuss sites depicting child pornography, the Cybercrime Department bases its activity on the Interpol's activity through the 105 unit, which I mentioned before. In the past couple of years, the Interpol has been managing a list commonly known as the IWOL, Interpol Worst of All list. And it's a list of websites depicting child pornography. And the IWOL is shared by the Interpol with ISPs around the world, and numerous ISPs have reached an agreement with the Interpol to block access to these websites on a voluntary basis. And in 2019, the Cybercrime Department demonstrated a significant rise in enforcement and prevention efforts, operating against 36 major websites that published prostitution services in Israel, from which the court ordered to restrict the access to 15 websites, granted an amended order to restrict the access to 14 other websites in cases in which the activity of the sites were transferred to another address. And that is a problem that we see because they keep shifting to new addresses. And nearly 3,500 websites depicting child pornography were blocked. And among the sites, which I mentioned before, of publishing prostitution, among these sites restricted to access are some of the largest and highly trafficked prostitution sites in Israel. And we had a site where Israeli consumers of prostitution used to express opinions and rank women in prostitution. So it did not publish the prostitution, but it ranked the women in them, and we convinced the court that it should be restricted as well. Moreover, we had a warrant issued and restricted a site that published pictures of women with no phone numbers, no description of what these women were doing, but we showed the court that this website with the pictures, this page became an online catalog for a site which shifted its publication via Telegram, and this site was restricted as well. Now, the remaining websites were removed, and therefore the Cybercrime Department retracted its request for restriction of the access to the sites. And as a result of this activity, we can see a significant decrease in the number of users of sites against which we have acted. We do see a shift in criminal activity to less central platforms, like I mentioned, like Telegram. But we do see that this reduces the exposure of the Israeli public to prostitution publication. So this is a new way to actually prevent. We cannot eradicate. We did not eradicate. We can see that we have new phenomena on prostitution online. People keep changing, keep developing, keep trying to see how they can do that. But the Cybercrime Department and the State Attorney's Office keep thinking outside the box to see how we can bring them all into justice. That's it. Thank you.
Thank you very much for this fascinating analysis of the cybercrime arena and trafficking and the innovative methods of enforcement and prevention. And I think actually this is probably the wave of the future, so that this was an extremely important presentation. Now, Chava, what do we want to do here? We are running late, I see.
Yes, well, Rana has a few questions from the chat, and we'll ask the panelists if they can make a few remarks. Thank you.
So we will start with the first question. It is addressed to Maria Grazia, but of course, Rachel, please feel free to address this to whoever, to any of the speakers. Where the protocol is a criminal treaty, is there an effective process where a complaint can be taken to a committee? Oh, can you hear me? Maria?
Okay. Okay. There's no, the protocol does not establish a particular court or committee. So it is not possible to address complaints to a particular body. Of course, criminal proceedings are to be launched on a national basis, and only in certain cases and certain particular cases these proceedings could be addressed the International Criminal Court, but only if there's the possibility to qualify the criminal behavior under the grounds provided by the courts, which means, for example, to qualify the crime as a crime against humanity or as a war crime. Of course, the national level remains the main level in which victims' rights should be recognized and respected and implemented. And we have to recall that states are the main human rights obligations are upon the states. So it is the state, the first interlocutor to be activated for the respect of victims' rights.
Thank you, Rana.
Right.
Thank you very much.
Thank you. Okay, the next question. What are the implications for a victim who is receiving rehab having to deal with it during testifying against the perpetrator in the prosecution process? Rachel, you're on mute.
Mute.
I think perhaps Judge Briel and Dina could refer to that question. So Judge Briel, do you want to answer that?
Mute, mute, mute. You're on mute.
It's very hard for any victim to testify in court, who is to be mentally prepared to testify in court, and certainly should be receiving services for the trauma that he or she has been exposed to. What we found is that the person testifying, the victim, really needs to be treated with dignity. In other words, they shouldn't have to come to court in clothing that that doesn't help them feel confident. They need to have preparation for their court testimony. Some defense attorneys would say that is coaching and would complain to me as the judge that they've been coached, but I don't think that's coaching. I think that's good advocacy to help prepare someone who's gone through so much trauma, who's dealing with therapeutic services at the same time they have to relive the situation in court. So it's important to make sure that any survivor testifying has therapeutic services. And I remember one young woman was taken to court in her jail garb. So she had committed other crimes and she had been incarcerated. And it struck me then, and I spoke to the attorneys about it later, that she should not have had to testify that way. She should not have had to wear her jail attire. And when she's really reliving the situation and she is helping the prosecutor out by talking about the situation. So I think it is tricky to have someone come to court when they have experienced all of the horrors they've experienced. Certainly there's the Victim Witness Protection Program that can be accessed in the United States. There's services, there's relocation, but it's hard to get. So those are some thoughts. I don't know what you think, Dina.
I agree with you, of course, completely. I'll just add that in Israel, we have a legislation, a special act that addresses the rights of victims of offenses, all offenses, but not just trafficking, but also including trafficking offenses. And our system works in a way that the state attorney's office is divided into districts. And and in each district, we have an attorney who is a specialist on trafficking cases, but also on this legislation on the protection afforded to victims of offenses. And they are in charge. Once a case is allocated to a district attorney, they accompany him, even if it's not their own case, but they always will accompany the attorney who was dealing with the case, and they will instruct him on how to, on what the law is. For example, they have to make sure that the victim is aware of the indictment and its details. They have to make sure that the victim, if there isn't any intent on signing a plea bargain with the defendant, then the victim can express her opinion about that. She can oppose a plea bargain, or she can express any opinion, and the court has to hear her opinion at least 2 weeks before the plea bargain is discussed. The victim is entitled to compensation, and the court must award compensation, but if he doesn't do so, then the state attorneys will appeal the decision and claim that there has to be compensation awarded to the victim. So all these, and also there are many measures that are pertaining to how the testimony will take place in court, so that the victim does not have to relive. She will have to go through the trauma again, but at least it can be done in the least intimidating way possible. And this is taking into account that in Israel, many of the victims are foreigners, and they don't have any support circles. They do not have family in the country. So victims in the shelter, for example, are always accompanied to court proceedings by a member of the shelter as a social worker or a counselor who knows them, just to give them moral support. Because of course, in the courtroom, the defendant's family will be there, his friends will be there. We had a case that they were making faces while a victim was on the stand, and the judge was looking at her in the audience, in the courtroom. His friends and family were making movements like this to the victim, threatening that they would, of course, nobody needs interpretation to that movement. And the judge didn't see it because he was looking at the victim and at the attorney at the time. This wasn't supposed to happen, of course, because she should have been allowed to testify behind closed doors. But these are some of the circumstances that happen. So what I was describing before in my previous words was that we do see the need of a legal representative that represents the victim in the criminal proceedings, because the state attorney, of course, represents the state. And although, as we said, he has many obligations that he has to fulfill, and there are guidelines of how to treat the witnesses, and they are fulfilled to the best of their ability, but at the same time, they're not really able to look after the victim's best interests while they're handling the court case. So we think that this is a necessary step, and that's why we're going in that direction.
Well, similarly to Israel, we have victim advocates that are in the courtroom with the victim and are allowed to stay in the courtroom when he or she testifies. We also, similarly to Israel, have something called Marcy's Law, where the prosecutor, the state's attorney, has to check with the victim, and they don't have to agree with the victim, but they have to find out what the victim wants to see in terms of sentencing, whether they're okay with the sentence they're recommending or not. Now, obviously, if the victim suddenly disappears, then they don't have to, there's no way to comply with Marcy's Law. And often it's really incumbent upon a judge to ask, have you gotten input from the victim about what you're asking me to do? So it's important. So very similar laws to Israel.
Thank you. Thank you very much. Very, very interesting. And we now have a request from Justice Radmila from Serbia, who would like to say, please, she was in Israel. I don't remember the exact year, but an amazing justice. And please, thank you. Please take the. You're on mute, Radmila.
Sorry.
Okay.
I said greetings to all of you. I was happy to visit your center. Greetings to Rachel and all my friends that I know, and we are all together in this fight, and me for long years. And I just wanted to inform you in a few words that there's ongoing fight in Serbia, of course, and we are trying to do some changes in judiciary, in prosecutions, in policy work. And Supreme Court, which I'm a judge of the Supreme Court of Serbia, in the last few years, we put on our agenda the issue of victims, and it has shown to be a good move. We publish under the OSCE project, we did some guidelines for judges and prosecutors in the issue of compensation of victims, because analyzing the judgments of courts, we found out that the compensation is neglected in the criminal procedure, and that all victims are somehow shipped to the civil procedure that they then don't do, and it's kind of delaying and torture for them again. So we somehow made a working group that I was member in that group, but also, which was very valuable, we had the judge of the civil department in the Supreme Court, who gave a really good effort and helped us to analyze how, under the criminal code that we already had, the criminal procedure code, we can deal with the issue of compensation easily. So we learned, which we knew, but somehow judges were lazy to do it because the law somehow allowed to judges that they don't deal with compensation if it will prolong the procedure. So they all kind of use it. But since the human trafficking in the criminal code of Serbia is in the same chapter with the war crimes and the crimes against humanity, which I think is a great thing, and it's something that I suggest to other jurisdictions. So it's high level of the crime, and also the values that are protected by that crime are the dignity, liberty, honor. And so we learned from our colleagues from the civil department that for breaking those values, you don't need to have expertise, you don't need to involve the experts and prolong the trial. You just compensate those values that are violated by the human traffickers, that, as I said, dignity and liberty and honor. So that was something really like the lightened for judges. That was in front of our eyes, but we just somehow didn't realize it. And we actually, under the OSCE project, had a lot of seminars on that issues, and the results are great. Now we have decisions, and we actually told to the judges that just knock on your civil judge, on the fellow civil judge, and ask him how much do you give for this and this issue when it's unmaterial damage. And that's how we dealt it. And also the colleague before me, she mentioned the plea bargaining. That was a problem too with the prosecutors. They are supposed to include compensation in plea bargaining, but actually they didn't do it. And somehow with this guidance, the Supreme Court pushed them also to do it. And we have in the practice now the plea bargaining where the compensation is also the part of plea bargaining. And I think that it's really important that prosecutors should be aware. It is the issue in the countries in Balkan and the East Europe that this is problematic, maybe not in the United States of America, where the role of prosecutors is much more bigger, but here still it's not like that. So that is something that was good move from the Supreme Court of Serbia. Also, we did a lot on non-punishment issue. And we, under the OSCE project also a few years ago, we promote the guidelines that were published in Serbia by the OSCE in Serbia, and which is also good solution in the law of Serbia, which is my suggestion maybe to put in the other laws, that we directly in our description of the law, we, as the way of exploitation, we have to be used for doing the crime. So this is in our law of human trafficking as a way of exploitation. So we have lots of verdicts in the last 2 or 3 years after the serious educations that this is the way of exploitation. And also what we did, the Supreme Court every 2 years issues the analytically, which I did also. I did it. I took 10 prominent judgments and analyzed them from different points of view, and we published that analysis. And this is like also useful for judges to see the other verdicts, to harmonize the court practice in the Serbia. And we found some really unique cases like the exploitations in the situation that is similar to slavery. That was really specific case where at the first instance, the defendants were liberated from the guilt because they found out that it's a Roma's family. They found out that it's a habit and blah, blah things, you know, that she was brought, the lady that was about 15 years old was brought to Germany for some forced marriage. But then on the second instance, that was a good judgment that used also all international instruments and conventions, and they found the family guilty for human trafficking. and they found the means of exploitation, and they really did a good description. So this is a case that we analyzed and spread around. And also the begging is a problem in Serbia. The begging, which is also described as a one of means of exploitation in our law, and we have a lot of it, and which is unique. That's where I will finish now. Now, unique is that we have two cases where we found the father of the Roma's family guilty for exploitation, using his children and wife for begging. But what was to differ the exploitation here, that we found out that this is not, that the money was not brought back to the family that they got by begging. The money was used directly only by the father of the family for his somehow extraordinary life, for drinking and getting other women or whatever. So that is also was some breaking case in the court practice in Serbia. So that's what I wanted to share with you. And my question is, how, for some of you presenters and whoever, how far did we go with the definition of labor exploitation? That is still ongoing problem in Serbia and the surrounding country, labor exploitation, especially in the poor countries where the people work for little money, and where is this, if someone has experience in that. Thank you very much, and my gratitude to be able to speak with you. Thank you.
Thank you very much. And it's wonderful to see you again. Rachel, I will pass on as our time. We have a lot, many more questions. I think we'll forward them to the experts and ask everyone if they can give short answers, and we will continue the dialogue. I'll ask you, Rachel, if you can summarize and bring out the highlights of the day, and then I will ask Ambassador Schlein to close the session. So thank you very much. I know there are many more questions, and we will write down, we're copying what's in the chat, and we will present them to everyone and get you the answers. Thank you, Rachel.
I think that the panelists that we were privileged to hear today remind us to step back and examine trafficking and the fight against it in broad terms. We all pay lip service to the importance of states fighting poverty and other root causes of trafficking. But we usually limit our prevention methods to information campaigns. These panelists remind us to go back, see the systemic roots of trafficking, and try to fight trafficking that way. We all stress the importance of victim protection, but how many of us really listen to victims? How many of us take prevention and protection as seriously as law enforcement? Each of these panelists has undertaken concrete steps to lay stress on broad-based protection and prevention. And here, maybe because I like philosophy and you are a captive audience, I must say that inequalities in society make people targets of trafficking. Vulnerable people, in other words, people who have unequal rights and unequal opportunities, they fall victim. And the questions raised by these panelists mirror philosophers like John Rawls and Judith Butler, who seek for equality, societal equality. They also mirror a new UNODC tool, which is a toolkit to mainstream human rights and gender equality in the fight against trafficking and smuggling. So anybody who's interested, there's a new UNODC toolkit. So I think that the basic message here is that we need to recognize that there are various societal ills which provide fodder or provide a basis for traffickers. Therefore, if we don't work to create a better and more equal society, the fight against trafficking will only be partially successful. And here, despite the problems in the United States right now, I want to end with a quote from the United States preamble to the Constitution, which says that we, the people of the United States, to establish justice and promote the general welfare. While these may seem amorphous aims, even utopian, the panelists before us have shown us concrete ways in which this may be achieved. So thanks to all of them.
Thank you very much, Rachel, for your insights. And I'd like to ask Ambassador Schlein to say the few words.
Thank you very much. I'm going to be very brief. I just want to thank all the wonderful people that spoke on our panel this evening, tonight, this morning, depending where you are. I thought that was very valuable, and I'm very happy that we could provide this platform. And I hope that we could continue working together and promoting this vital campaign. So thank you so much, and goodbye.
Thank you very much, Einat. And thank you, everyone. It was an amazing panel. There's so much more to discuss. We could go on and on. And I thank you all for taking time out of your busy schedules. And again, thank you to the staff here, to Rachel, to Alexander Kara, advocate, and Justice Brielle, advocate Gershoni, who I'm missing, Dina Dominance, and did I miss someone, Rachel?
Maria.
Almost, I don't believe it. Our dearest friend, who is amazing and has done so much work in the UN, in Italy, all over the world. Thank you so much for coming on. And you were amazing as always. And we hope to greet you all in Israel very soon. So
I hope so.
thank you very much to everyone. Toda raba.
Thank you.
Thank you.
Bye.
Toda.
Radmi.